My name is Dana Gold. I serve as Senior Director of Advocacy and Strategy and Director of the Democracy Protection Initiative of the Government Accountability Project, a nonprofit, nonpartisan, public interest whistleblower protection and advocacy organization that for nearly 50 years has sought to promote government and corporate accountability by protecting whistleblowers and ensuring their disclosures make a difference. Government Accountability Project has led or been on the front lines of campaigns to enact or defend nearly all modern whistleblower laws passed by Congress, including the Whistleblower Protection Act of 1989, as well as the 1994 and 2012 amendments to this legislation. This is the primary law that empowers federal employees to report violations of laws, rules, or regulations, gross mismanagement, gross waste of funds, abuses of authority, and substantial and specific dangers to the public health and safety, free from retaliation. And the Whistleblower Protection Act is embedded in the Civil Service Reform Act of 1978, which is the cornerstone legislation that protects the merit system that has been in place since 1883 to ensure that federal civil servants are loyal to the Constitution and the rule of law rather than to a president, administration, or party, and are protected from inappropriate political interference in their hiring, firing, and the execution of their work, fulfilling the mission of their agencies that serve the public's interests. They have due process rights protected in the merit system, including, but not limited to, their rights to report wrongdoing, to refuse to obey illegal orders, and to not be gagged from exercising their speech rights. These rights encourage expertise, continuity, and commitment to government service rather than political patronage. But more importantly, they recognize that employees committed to compliance with, and in the DOJ's case, enforcement of the Constitution and laws passed by Congress are the best mechanism for accountability because they are in the best positions to discover, prevent, or mitigate serious illegality, abuses of power, and dangers to public health and safety. Not only do we just need nonpartisan civil servants to execute the functions of government that touch on every aspect of our lives, we need them to be able to warn against misconduct that undermines those very functions, such as protecting against unsafe meat, poultry, or baby food, nuclear weapons explosions, healthcare fraud, and railroad and airplane disasters like the tragic one that occurred earlier this week. The relentless battery of attacks on the civil servants across the government, and particularly at the DOJ, it's a blatant effort to literally remove or drive out the federal employees who are the guardrails of accountability. And indeed, these efforts, consistently executed without compliance with employees' due process rights, and in many cases amounting to prohibited personnel practices, have the additional effect of chilling employees from exercising their rights to blow the whistle or defy illegal orders for fear of suffering retaliation with impunity, further undermining enforcement and accountability mechanisms by suppressing reports of evidence of misconduct. The fears of retaliation and futility, which are the two primary reasons employees stay silent in the face of wrongdoing, could not be more real in an age of political violence and profound challenges in the integrity, functionality, or sometimes both, of the three branches of government. My colleagues today have talked about challenges to many of the actions targeted at wide swaths of employees working on matters undesirable to the current administration, such as DEI initiatives, the Fork in the Road memo, and others. But we are already starting to see speech-based resistance to the policy's implementation, both the consequences of these executive orders and memos that have been coming down for the past 2 weeks and the manner of their execution. Today, employees still have rights and avenues for recourse, even if weak and under threat. They also have resources. For rights, DOJ employees and almost all federal employees have rights to report wrongdoing, to refuse to obey illegal orders like Nicholas Gottlieb of USAID did yesterday, and to not be gagged from exercising any of their speech rights by illegal non-disclosure orders or directives. There are key elements of the Whistleblower Protection Act embedded in the CSRA. Employers may not take or fail to take or threaten to take or fail to take a personnel action with respect to an employee because they disclose information they reasonably believe evidences a violation of law, rule, or regulation, gross mismanagement, gross waste of funds, abuse of authority, a substantial and specific danger to public health and safety, and also scientific censorship that would result in any of these forms of misconduct. This is not just illegality. This is like a wide swath of issues that are protected because we recognize that employees are the best defense against wrongdoing. The standard is reasonable belief, so it's verified information, what we used to call truth. And the range of issues that are protected are wide because we recognize that employees are the best mechanisms for compliance, risk management, and protecting the public interest. They do not have to go through a chain of command to report problems. Their disclosures can be formal or informal. They can be made to the OSC, which receives and investigates disclosures, but also to the IG, to Congress, agency officials, law enforcement entities, and the press. They are all protected recipients of information, and that information catalyzes the mechanisms of accountability, including this body's role in conducting oversight. They also have the right to refuse to obey orders that would require the individual to violate a law, rule, or regulation. While the burden is on an employee to prove the illegality of the order, it is not a reasonable belief standard, so it's riskier to the employee, but they can stand firm against illegal orders. Finally, they have recourse. They can, the Office of Special Counsel can order a stay of an adverse personnel action rooted in whistleblower reprisal. They may also appeal, in some cases, a prohibited personnel action directly to the MSPB. Union collective bargaining agreements may be the one remaining mechanism, depending on the attack on the existing federal whistleblower rights. But union CBAs may be one of the remaining mechanisms for enforcement of whistleblower rights, because whistleblower rights and adverse actions are recognized as unfair labor practices by union arbitration. Of course, as unions are under attack, this becomes a new remaining threat to the rights of employees' speech. Currently, federal employees do have to choose between filing a grievance or pursuing the OSC. So there is a choice of venue problem there, but it is a really powerful enforcement mechanism. There are grave threats to these whistleblower rights of federal employees, as I've said, in terms of Schedule PC that would reclassify employees and strip them of the independent review of their whistleblower rights by the OSC and MSPB and put it with the agency on which the whistleblower is reporting wrongdoing and alleging reprisal. So it would be the fox guarding the hen house of whether or not those rights are actually enforced. So if that is gutted or politicized, we are going to have a problem on our hands with a greater chilling effect. There are resources, as so many of my colleagues have talked about. We have provided resources for years on our website at www.whistleblower.org about truth-telling in government, a guide to whistleblowing for federal employees, contractors, and grantees, which will be updated soon. A book we have published with our friends at Project on Government Oversight and Public Employees for Environmental Responsibility called Caught Between Conscience and Career, Expose Abuse Without Exposing Your Identity. We are working and conducting trainings with our partners at Partnership for Public Service, with AFG, with civil society organizations who often receive whistleblower information to make sure they know how to provide protection and work with a whistleblower safely and effectively. The House Office of the Whistleblower Ombuds has amazing resources available to whistleblowers and employees thinking about exercising their rights, as do our friends at civilservicestrong.org, where all of this information has been curated. Finally, we are creating an army of pro bono attorneys. We have already trained them to do rapid response intakes and provide support to whistleblowers so we can quickly file retaliation complaints, as well as disclosures to ensure that they receive protection and legal support. Employees are already vulnerable. What might be good is the fear may be turning into anger. The more employees can exercise their rights to speak up about wrongdoing or to refuse to obey illegal orders, the more they will inspire others to do the same. And we have seen for decades the power of one individual to make a difference when they exercise their rights, and their duty, having taken an oath to uphold the Constitution, to speak truth about illegality and abuses of power. They don't catalyze accountability alone. They need expert legal support, protection by Congress, protected independent oversight mechanisms, support from civil society, bringing lawsuits on whistleblowers' underlying disclosures and other advocacy, reporting by a free press, and their rights not only protected but strengthened. Civil servants are the only major sector of America's labor force without court access to defend their free speech rights. Whistleblowers have been vital to accountability no matter which administration or a party holds power. Nothing could be more true now. Thank you so much for your concern and support for our federal employees and this unique and powerful mechanism of protection that they deserve.